Hello, everybody. Welcome back. This is Roger Royce. I'm a startup lawyer in Palo Alto, California. This is the 10,000 Startups podcast. We've talked before several times about the difference between founders and fraudsters in this valley and some of the high profile startup fraud cases. Today, I'm going to continue on that theme, but take a little bit of a twist. I mean, not so much about the people that fake it till you make it to a little too much. But what about the people that do business with them? Should you be concerned, especially when you see people clamoring for social proof all over this valley? Even I have gone to a lot of trouble to go pose in a photograph with Sam or Elon, and I know how that goes. So it's easy to be fooled in this valley. What happens when you are fooled? Do you have any problem? So I'm going to title this episode "When the Fraud is Over, but the Liability Isn't." Now, when you think about a massive Ponzi scheme, you might think about two things, the fraudster and the victims. But, there's a third group, people who weren't criminals, but still had to give money back or had liability or somehow got in trouble themselves. And today I want to tell you about somebody from my part of the country who's not much older than me, in fact. He came up about the time I did, a fellow named Tom Petters, a very, very famous and celebrated Minnesota businessman. He was later convicted, it's been about 20 years ago now, of running well, probably not 20 years, but quite a while ago. But he was convicted of running a $3.5 billion Ponzi scheme. Okay, and if that's all that happened, this would be a very short episode, but there's not. So let me give you a little background. So I want to tell you how the money that he was convicted of stealing basically was tracked down, it was clawed back, and then redistributed. And sometimes it was taken back from people who had no idea they were involved in a fraud. So here's what happened. So Tom Petters, like I say, he was famous 20 years ago. You would have heard of him because he was the CEO of Petters Group Worldwide, which was a big business empire based in Minnesota. And you know him because he had acquired household names like Polaroid using investor money. He had an airline called Sun Country. He had an online internet business that generated more than $1 billion in revenue. So talk about legitimacy. This guy looks as legitimate as they come. But underneath it all, he was running a Ponzi scheme. What do I mean by a Ponzi scheme? Well, investors were told their money was financing short-term purchases of consumer electronics for resale, but in reality, there were no consumer electronics. The new investor money was just being used to repay old investors. And to keep the thing going, of course, you got to give them a big return, huge returns. Might remember I talked a little bit about the case of Juan Levon, which a documentary was made about, kind of did the same thing. That's classic Ponzi, right? You don't have to go very far. History is just full of these. Anyway, so pretty simple idea, pretty simple scheme. But it eventually, like all Ponzi's, it had to come to a head. It had to unravel at some point. Eventually, you're going to run out of investors and greater fools. And that happened in 2008 because one of the participants, Diana Coleman, she went to the FBI. And not only did she turn him in, she became an informant, wore a wire. They should make a movie about this. Anyway, so 2009, Petters, was convicted of wire fraud, mail fraud, and money laundering, and he was sentenced to 50 years in federal prison. Okay, that is not the end of the story. That's the start of my story. I don't do criminal law. I do corporate law. And why do I care about this? Well, let me tell you why. Um, because now the fraud stopped, but a lot of people lost a lot of money. That money doesn't magically reappear, right? And usually it's just gone. It's spent, and it's all the usual, the fleet of, fancy cars, the Ferraris, the private airplanes, the vacations, the villas, the houses around the world, all that stuff. So it's someplace. And when that happens, the court, in this case, the bankruptcy court, will find somebody to go gather up those assets and dispose of them and then pay people back from the proceeds, the victims. And in this case, they appointed a federal receiver, bankruptcy court, not to prosecute bettors, but to find, preserve, recover assets, and liquidate them so there'd be money to distribute to his bankruptcy estates. Now, that meant he had to unravel more than 150 different entities all over the world, liquidate the property, and then coordinate with federal prosecutors. And the ABA just did a podcast on this in their podcast series, Bad Boys of Bankruptcy. If you're really interested in the details of that, you should listen to that. But I'm not focused on that here. I'm going a little beyond that because here's where things get really uncomfortable, right? So we know in a Ponzi scheme, there's going to be losers, people who invested and didn't get their money back. But you know what? There's also winners, right? There's people who invested and made the returns they were promised. Well, the problem is under bankruptcy law and under fraudulent transfer law, state law, uh, we also call that avoidable transfer law. The net winners are sometimes required to give their winnings back, even if they did nothing wrong. So in the Petters case, the an attorney was brought in by the court to go and commence those cases. We call that clawback litigation. It's not to punish people, it's just fairness. They want to get back what they shouldn't have gotten, recover it so that the victims can share it proportionately. So here's the key legal question. Does someone have to know about this to be liable? Right? I mean, I thought he was a legitimate guy. I mean, look at these legitimate businesses and talk about philanthropy. I mean, this guy Petters, he gave money to like so many different charities, which had to give the money back, by the way. So here's the problem. In most cases, actual knowledge of the fraud isn't required for someone to have to repay. Courts will typically ask, did you receive money? Was it more than your principal? Was it received within the applicable look back period or statute of limitations? And if yes, you may have a problem. So that's why early investors, business counterparties, vendors, charitable institutions, they can find themselves pulled in to one of these cases. Now, bankruptcy law is the primary engine on this. I mean, bankruptcy courts have enormous power. It's a court of equity, meaning that it can do a lot of things. It can just order things to be done. Um, and most of these clawback actions are brought under the bankruptcy code. There's a fraudulent transfer section in the bankruptcy code, 11 USC 548, which allows the trustee or the debtor in position to avoid transfers made within 2 years before the bankruptcy filing if they were made with actual intent to hinder, delay, or fraud, or constructively fraudulent, meaning that meaning that the bankrupt or the debtor got less than reasonably equivalent value while it was insolvent. In other words, I just gave my assets away to somebody and it made me insolvent, or I was insolvent when I did it. That can be clawed back. That's the easy case. So there's a Ponzi scheme presumption that transfers made in furtherance of the scheme are presumed to be made with that actual fraudulent intent. So the claimant doesn't even have to prove subjective intent transfer by transfer. And that's why winners can be sued even if they don't have knowledge or complicity. But it doesn't end there. We've got a state law counterpart here, which has a longer statute of limitations, and that's our state avoidable transfer or fraudulent conveyance statutes. And most states have a Uniform Fraudulent Transfer Act or a Uniform Voidable Transactions Act. And these state laws are pretty important because they allow for a longer statute of limitations, up to 4 to 6 years, usually, sometimes longer than the bankruptcy law does. And state law can get pulled into a bankruptcy as well because a trustee steps into the shoes of a creditor and can bring a state law fraudulent transfer claim. So don't think that short 2 year statute of limitations is going to allow you to not be looking over your shoulder if you do business with one of these folks. And even if you're not in a bankruptcy case, there can be a clawback purely from state law. Creditors, receivers, assignees. We did a whole episode on assignment for benefit of creditors, so you know what that is. Can proceed under the state law fraudulent conveyance principles, but usually the larger schemes will end up in bankruptcy or federal receivership. But just suffice it to say, there's lots of angles. There's lots of tools in the toolkit for somebody who wants to get some money back. Now, why do these innocent investors still have to pay? I mean, it just seems so unfair. Well, keep in mind, clawback liability is not punishment. It's remedial. It's equitable. It's not a question of fault, but it's rather whether you, the investor, or the counterparty received money that should have been available to all the creditors. So, the return of principal is usually protected under a value defense. In other words, you just got back what you put in, but not your profits, because legally that's other victims' money. And this doctrine applies under both bankruptcy law and state law, although there are some defenses. And like I say, the statutes of limitation vary. I'm not going to dive too much deeper into that. I'm not going to say you always lose or that you never lose. I'm just saying that you have some exposure and you really have to dive deep into the facts and see if there are any defenses. Now, how this played out in the Petters case is really is kind of disturbing. Actually, it's kind of shocking because of who had to actually give money back. Let me get to that in a second. But first of all, in that case, it was a Chapter 11. That's how most of the money came back. That's bankruptcy. Some of it came through a federal receivership. And the trustee or the federal receiver used state law theories alongside bankruptcy powers to get money back. Like I said, vendor payments, investor profits, but you know what? Also charitable donations. And that's a really striking aspect of this case because Petters was extremely magnanimous. Now we know why, but he donated $5 million to the John Petters Ethical School of Business at Miami University in Hawaii using stolen funds. John Petters was his son who was killed, I think it was in Italy, and he created this fund for the college that his son had gone to. So even charities acting in good faith can be required to return donations. And in fact, that happened in this case. And those funds were clawed back, taken back from the charity, redistributed to the victims. This recovery was global. There were lawyers in more than 30 countries to go after the assets and the net winners abroad. And as you can imagine, it went on for a long time, cost a lot of money, and created a tremendous amount of problems for everybody else. In fact, one of the big investors, you go look this up on Wikipedia, there were two hedge funds that had lost money in this. And then they went and lied to their investors about the fact that the notes they purchased from one of Petter's entities weren't any good. And they ended up, having their own personal legal problems because of it. So it really trickled down. But what I want to leave you away with is that first, you don't have to be a bad actor to have legal exposure after a fraud. Second, if you get profits from a fraudulent enterprise, even unknowingly, that can trigger a repayment obligation years later. And third, due diligence isn't just about avoiding losses, it's about avoiding downstream liability. And finally, when fraud is uncovered, the asset recovery is where the real juice is in these cases, not the criminal punishment. Now, you'll notice that in my world of startups, there's a lot of, like I said, a lot of fake it till you make it. And the savvy investors they do deep due diligence and they tend to be very suspicious. And you'll find that in the bigger transactions or the smarter investors, they almost always do background checks. They want to know who they're doing business with. And as I heard about this case and followed it, I kind of wondered, would that have been enough? Would that have uncovered this? Probably not. Because until it unraveled, there was no reason to believe that there was anything wrong here. So it's one of those scary things that ought to keep you up at night. So Tom Petters himself, he's going to probably spend most of his life in prison. But like I say, the real story here and the one with the lasting impact is how courts, receivers, professionals work for over a decade to unwind that damage and claw money back. And if you ever wondered how fraud victims are made whole, or how innocent participants can be drug into these cases, go read up on the Petters case, as that's exactly what happened. I hope you found this helpful. If so, please like, subscribe, and share. This is Roger Royce with the 10,000 Startups Podcast.